we look back at 2021, we turn our focus now to South Africa's judiciary. We unpack how the courts performed this year and whether improvements are needed as we look ahead to 2022. Here to help us unpack this, I'm joined by former Constitutional Court Justice Albie Sachs and constitutional law expert with the Cape Bar Society of Advocates, Michael Osborne. Gentlemen, good evening and thank you very much for your time tonight on In Focus. Justice Albie, has the judiciary in 2021 been successful in ensuring its independence is upheld and its authority is not undermined?
Well, it's been a hell of a year for the judiciary. Wow. And of course, that's what a constitution is there for. It's not just there for fair weather. It's there for the hard days. And we've had so many different challenges. The pandemic and the impact on the pandemic on general elections. And should the pandemic mean the elections are postponed? A commission, somebody is appointed to inquire, no less than Dikgang Moseneke, one of our great jurists, and he said it ought to be postponed. The matter, his recommendation, accepted by government, is taken to the Constitutional Court, and the court says no. The court says no against the government, against one of the great legal luminaries. And I think in general terms, life itself, as it were, the course of the pandemic has justified the decision taken by the court. You don't move elections out of the constitutionally prescribed limits unless there's absolute necessity. So I think the court came out reaffirmed or confirmed in its stature and in its independence.
Yeah.
Another challenge to the court, intellectual challenge, related to some very, very little known independent body insisting that under the Constitution, independents should be allowed to stand for national parliament. They can stand as ward councillors at the local government election, but there's nothing in our Electoral Act allowing for independents to stand on their own if they don't belong to a party. And in a very path-breaking decision, the court said that the literal wording of the Constitution says everyone has a right to take part in it, to stand for elections, and that means it's not everyone who belongs to a party, and it's been a real conundrum, a headache, if you like, for the Parliament now to reconcile independent candidates with the proportional representation system party lists. It's battling. It's got 2 years to do it. I think we're halfway through that period. But again, the court has shown its creativity and its independence. The biggest direct... Shall I carry on?
Yes, you can. You can, Judge.
Yes, the biggest direct challenge was to the authority of the Constitutional Court itself when it ordered former President Jacob Zuma to be imprisoned, issued a warrant for his arrest because of his contempt of that court, defiance of an order of that court. And that issue is very, very hotly debated, but it certainly showed a very, very independent court. There was massive contestation. Many people feel there was actually a quasi kind of insurrection mobilized against it, against that decision. There are very, very vituperative attacks on the court for having given the decision that it did. I would say internationally, amongst lawyers and judges throughout the world, and I'm sure the great overwhelming majority of judges in South Africa, the court is right, not simply because it is the court, but it gave a decision that was very strongly reasoned, was very forceful. There was a minority opinion, and one of the strengths of the court is that it doesn't insist upon simply the majority view being given. The minority of 2 judges were able to express their alternative views, but it was only 2 out of, I think, 10 judges expressing that position. So my sense is that the integrity of the Constitution has been upheld in this past year, and the independence, the resolution, if you like, resoluteness of the court as an institution and the judges who make up the court has also been upheld in a very, very testing, very, very, very difficult year. Difficult for the country, difficult for the judges, difficult for the lawyers arguing the cases, difficult for everybody. But constitutions are not made simply for easy times. They're made for difficult times.
Yeah, indeed. Michael, I mean, those two cases that Judge Albie Sachs has pointed out, do they make a case for the judiciary that they upheld the Constitution and the law impartially? And let's look at each one in isolation. I mean, if you begin with the big one, of course, we are still suffering the side effects of that. With tomorrow, we will be hearing another application for leave to appeal, rather, that particular matter of the arrest of the former president being sent to prison for 15 months. What in that judgment should we look at that would really tell us that the courts here acted impartially and they were just purely independently applying the law?
Yes, the concept of independence and impartiality are problematic because we know that no human being and no institution are entirely independent or impartial. Judges bring their assumptions and their inclinations and their ideology to the bench with them. And then beyond the personal, you look at the institutional level. The Constitutional Court, like all of the leading elements of our constitutional dispensation, have a certain institutional heft and trajectory. And so in the context of a case like that of former President Zuma, you must take that into account, and we need to disabuse ourselves of the assumption of complete impartiality. And at best, what in fact we can hope for is independence. I think impartiality is a much more problematic notion. But yes, as Justice Sachs has said, the court faced enormous pressure, more pressure than I think it's faced probably in any decision in the past 2 decades or so. When you with the situation of a popular and populist leader like Mr. Zuma being quite shockingly confined to a cell. And it took a long time to come down with its decision. And people were wondering why we weren't hearing anything from Braamfontein. But then it did come out with I thought, a magnificent majority judgment, which I don't think anyone who's not entirely partisan, or anyone who's not committed to the values of the Constitution, could say was not a tour de force, truly an extraordinary decision. And I struggle to think of analogies in the constitutional jurisprudence of other countries. And I can't think of any at the moment. I think this was a truly dramatic decision, which cements, I think, the already very well-established reputation for independence of this court. I will say that it has been a difficult year, of course, as Justice Sachs says. Another institutional difficulty has been the departure of the Chief Justice and an interregnum in which the court has no permanent leader. Somewhat of an unsatisfactory situation, I should say. Yeah. But notwithstanding that, the court is bigger than any particular personality. Yeah. And I think it's come through magnificently.
Advocate Osborne, I'm going to come back to that and talk a little bit more about that particular matter, the appointment of judges. We've seen something happen this year in particular where the JSC convened interviews for judges, and that particular process was challenged, and that process had to be redone. And I'll get your views on that in a moment when we continue here. Did the judiciary hold its own in 2021? Is a question that we are exploring. Stay with us. In Focus continues next. Welcome back. You're live with us on In Focus, Newzroom Afrika, Channel 405, as we reflect on the year 2021 and look at the various institutions in the country and how they have fared. We have with us former Concord Justice Albie Sachs, as well as constitutional law expert Michael Osborne. Advocate Osborne, let's talk about that particular matter. I mean, you already mentioned the fact that we actually currently are still awaiting the president to announce who will be the next Chief Justice. But the JSE conducted a process wherein judges for the various other courts would be interviewed so that they can fill those positions. That particular process, I think it was KSEC that raised the issue, as well as other parties, that those interviews were not conducted correctly and had to be done. It was challenged. In a sense, even other judges pulling out of that process altogether. Is the judiciary all the poorer because of that, or did it help to strengthen the process?
I'm not sure I entirely understand your question, but what I will say is this, is that it's, I think, if anything, once again, a sign of the vitality of the system, that even an institution like the Judicial Service Commission it does not escape the scrutiny of the courts themselves. And commentators have said that it's remarkable and disturbing that, having had an opportunity to conduct the exercise a second time, the JSE would have come back with precisely the same result. But that in itself now is, I understand, being challenged, and we await the outcome. It's a remarkable and fascinating process, the kind of dialogue between one of the Chapter 9 institutions and our country's courts, and I watch with interest.
Yeah. Justice Sachs, it has raised a question around whether or not the political background or even other background of judges is relevant in their interview for particular positions in particular courts. Is that a necessary and a healthy conversation to be having right now in South Africa?
I don't recall it actually being an issue as such that's cropped up in the hearings of the Judicial Service Commission.
Well, some of the questioning, Judge, let me just contextualize. Some of the questioning during the interviews was around the friendships that the judges have with politicians and their backgrounds and their political affiliations. And the issue that was raised was that what's the relevance of that line of questioning when it comes to the work that they are going to be doing?
I seem to recall in one case there was one suggestion that the judge had been appointed, I think, by the ANC to some position or not. Would he be independent? And I don't think that's an unfair question, provided you don't push it too hard. In my own case, my whole life was with the ANC for 30 years or so. Before I was appointed, it was very well known. And there were questions, very hard questions, put to me at my Judicial Service Commission hearing. Would I be independent? And of course I said yes, and I like to believe that I probably gave more independent decisions possibly than any other judge did. So I don't think it's a question of where you come from politically, if you happen to vote for the DA or EFF or ANC or belong to the Black Lawyers Association or NADEL. I think these are background factors, but they shouldn't be central factors. What you want is the quality, the integrity, the objectivity. I agree with Michael Osborne. You come as a full-rounded human being with lots of predispositions, but you deal with them and you try to make sure that I like to draw a distinction between impartiality and neutrality. You shouldn't be neutral on torture, on racism, on homophobia. You've got to take a stand, the stand that the Constitution demands. But you should be impartial in the sense you listen to everybody. You give everybody an equal hearing, and you weigh it up in rational terms that are defensible. Clearly, the JSC got into a bit of a wobble in the last year or so. I would say more or less uncharacteristically so. There have been at times abrasiveness, rudeness. Some JSC members, I think, have been sharpening their own axe too much. Maybe it should have been more control from the person presiding. But in this one particular case, it seemed to be going off the rails. And when there was a legal challenge, the JSC decided, well, we might lose that case in court. Let's have a complete rehearing. And none of the candidates were nincompoops or totally out of question being the best people to be chosen. But that debate will continue. Now we're in a position where we're eagerly waiting to see who will be chosen as the next Chief Justice. And although it's taken more time, I feel it's such an important appointment that the President has done the country a service by setting up a committee to receive nominations, to make a short list. And I'm speaking now as Albie, now not the former judge. I think we have 4 superb candidates. All of them would make an excellent Chief Justice. And that's saying something about this country. Each one very different in personality, in style, in ways of thinking and speaking and doing things, but each one very clever, very hardworking, and imbued with the values of the Constitution. And it might be that the delay in choosing the other members of the court might be partly attributable, I'm purely speculating now, to deciding first who the Chief Justice will be, and the gender question might come in there. That might have an impact on gender in terms of the other appointments to be made or certain kinds of balance to be achieved. I don't know. But hopefully, within a few months, we will have a new Chief Justice and we will have a court with a full complement of 11 permanently appointed judges with vacancies only when judges go on leave.
Yeah. Michael, one of the issues that's being raised, particularly about this year, is the Crown Court in the matter of former President Jacob Zuma being the court of first instance. And those who are arguing against it, saying, well, this will have serious implications for the judiciary and the country going forward in the future. Are they making much of something that otherwise is not an issue? What's your analysis of it?
Well, there are other cases where the court is first and only instance. There are certain matters that can only be heard by the court, so it's not something unique. Questions of for example, the authority of the Speaker, I think that has to go straight to the court, where it's Parliament itself where the issue has arisen. Yeah. So that's not something that's specially been done for this case. Yeah. But in this matter, because of perhaps the stature of the person concerned, the importance of the Commission of Inquiry, the matter was referred to the top court that normally is the only court that can question the conduct of the President for a decision in terms of attending the court and what the consequences should be. And that could be said in a sense as being respectful of the status of the former president, not the acting president, but the former president, that it wouldn't be a high court judge who would have to rule on that particular matter. Those issues were canvassed by the minority position and the majority position. I personally, now speaking as Albie, former judge, agree with his characterization of the majority decision that this was a flagrant contempt of court. It couldn't have been more flagrant, more open, more transparent, if you like, and so logic, international precedent, everything that to my mind would support the decision that was taken, and South African precedent as well.
Yeah.
But I respect the minority positions, but I don't think the weight of legal opinion favors the majority view. Right. The one issue where I, again, speaking as Albie, do respond, perhaps very subjectively, is on the term detention without trial. I feel so strongly about that because I was detained without trial, 168 days in solitary confinement, nothing to do, no one to speak to, no contact with families, and detention without trial in South Africa had a very specific historic meaning. It was the way the security police took over court cases and became more important than the judiciary deciding on guilt. And that was where our people were tortured to death, clients of mine were tortured to death, where people went out of their minds, where terrible things happened. To equate the processes involved in this particular matter to detention without trial, I find absolutely ludicrous and very disrespectful to all of those of us who suffered under real detention without trial in the terrible days of apartheid.
So sorry, Michael. Yeah, we'll give you this final bite. What are your thoughts on that?
Yes, of course, Justice Sachs is right. The other remarkable argument one has heard from the counsel for the former president is that we are talking about a capital punishment, that the inevitable consequence of returning the former president to detention would be the loss of his life. Once again, this is I think this is one of these extraordinary situations where the arguments being made from the bar are so obviously absurd that it's not out of place to reject them entirely. It's a shameless attempt to mobilize a terrible history in the name of opportunism, and it's not a legal argument at all. It's an affront. So yes, I can only agree with Justice Sachs on that.
Looking ahead, I mean, is it going to be an even more turbulent time for the judiciary in 2022, considering the nature of our politics and how volatile they have been, at least in the last 18 months? Michael?
I'm sorry, are you saying what are the prospects of 2022 being equally volatile?
And there are texts that the judiciary has endured in 2021, and how difficult are things going to be for the judiciary in South Africa, even going ahead?
Well, I don't have a crystal ball, but I've got no reason to think that things will become less turbulent. There's still going to be an appeal with respect to the former president's reincarceration. I suspect that will end up going once again to the Constitutional Court, perhaps to a Constitutional Court that is reconstituted. The political volatility, the number of coalitions that have had to be formed in local government because of the results of the elections, that itself, that political instability is inevitably going to be sublimated into into litigation going forward. So that's just another area where we can predict interesting times in the judiciary, or for the judiciary.
I appreciate your time, gentlemen. Thank you very much for coming on, Justice Sachs, and Michael Osborne. Thank you very much for your interventions here tonight.